come back to speak about the enforcement of the penalty, because it's not it's one thing to decide about to decide a penalty or sanctions, but another thing is to enforce it. And we have, in fact, two situations. The first one is when the controller or the processor is physically present in the EU, and the other one is when the controller or the processor is not physically present in the EU. So there's an easy one. It's the first one. If the company against which a sanction has been pronounced is physically present in the EU, we've seen that the GDPR has organized a coordination of the actions of the DPA. So we assume that the DPA will take the necessary measures, or will organize themselves so that the sanction is pronounced where the controller or the processor has sufficient assets to guarantee the payment of the penalty, or to guarantee that the measures that are required are taken. We must also bear in mind that in case a DPA pronounces sanctions against a company and the assets of this company are located in another state member, or member state, sorry, the European Union has organized also some rules and tools between the member states to make sure that the fines and decisions are enforced without seeking the assistance of courts. So the enforcement is pretty much automatic in the European Union between the member states. The question, or the answer to the questions, will be different if the controller or the processor is not physically present in the EU, and, for example, operates his activity from Dallas, Texas, or Des Moines, Iowa, and Sherwin will develop about this subject better than I will do. Sherwin, I leave the floor to you.
Thank you, Frederick. Unfortunately, my answer is going to be very short, or my contribution here, only because we don't have much guidance on this yet. Obviously, if a U.S.-based company has an establishment in the EU, what Frederick just talked about and the sanctions that Henrik described would be enforced against that establishment. The question, I guess, would be, what about these companies who might be tracking European consumers through their web beacons and similar technologies, and to what extent they could expect to be fined or have some sort of enforcement action against them. And right now, I guess the principles of international law would apply, because there's really no agreement between the data protection authorities in the U.S. and the EU, other than some of the agreements we have already, which can serve as a precedent, I suppose. So, for example, the Privacy Shield agreement, and then also the post-Snowden revelations, which produced or led to the Judicial Redress Act that permits European citizens who are impacted to have some rights of recourse in U.S. courts here if their information is provided to government authorities improperly in violation of that act. So right now, the jury, so to speak, is still out on that, but I think no U.S. company should take solace in that state of affairs. I think it's just a matter of time, but the bottom line is EU regulators can certainly fine U.S. companies for violating the GDPR, and they will most likely be able to do it with the help of U.S. authorities. Frederick?
Yes, thank you, Sherwin. And we have also to keep in mind that if the DPA or the European member states may have some difficulties to collect administrative fines in the U.S. or elsewhere, the DPA still have a very efficient tool which is the possibility to stop the data flows to a specific recipient in a third-party country, which could be detrimental to the operation of this company in Europe. Then the second topic of this slide is the right to an effective judicial remedy against a supervisory authority. And because we are all living in democracy, of course, the company against which a sanction has been pronounced have a judicial remedy against the decision of the DPA. The GDPR does not provide for time limits or for any specific procedures, and in fact, it belongs to each member state to define the rules and procedures necessary to enforce the regulation and to provide the necessary guarantee in accordance with state member laws. Then, for example, in France, the processor or the controller against which a sanction would be pronounced may have a recourse against the administrative courts and then an appeal to the Court of Appeal in France, and even a third level of appeal against the French Supreme Administrative Courts, which is called the Conseil d'État. So the companies are granted 3 levels of recourse against a decision of a DPA. And the third and final topic for me is deals with the grounds for exclusion of responsibility. The GDPR provides, like the French civil law, for example, that a controller or the processor can be exempted from liability if they can prove that they are not in any way responsible for the even giving rise to the damage. So they have to bring the demonstration, of course, against the demonstration to the contrary that will be brought by the complaining party. But they have the right to defend and the right to of course bring all necessary evidence that they are in no way responsible for the damage claimed by the claiming party.